And we have everything coming up online. I hope everybody's doing good tonight. I wanted to take a moment just to read through at least the first part of some information from Julian Assange's court trial. Most specifically, the defense's opening statements. It's a 28-page document, so I'm going to have to do this in a couple separate parts. But I just wanted to make sure that I got this information out to everybody because I think it is still super relevant. Because Julian's case is pretty much in limbo at this point. We're not. It's still scheduled to begin on May 18th, but London has had a bunch of crazy stuff happen. The coronavirus is going around, so I just want to take a moment so that way everybody can at least get this, and then I hope you enjoy. I probably won't be responding to chat too much as I get this kicked off. So I hope you guys appreciate it a little bit. So here. In Westminster Magistrates Court, between Government of the United States of America versus Julian Assange. Opening statements of defense case. 1. Introduction. Course to be taken. I would first like to deal with the history of this prosecution, because that history shows that this prosecution is not motivated by genuine concerns for criminal justice or by politics, but by politics. Not that I will Next, I will summarize the three ways in which we say these proceedings constitute an abuse of process. First, because the prosecution is being pursued for I fucking suck. Alternative political motives and not in good faith. It engages the jurisdictional recognition in the successive case of Birmingham and Tolman. Secondly, because the request fundamentally misrepresents the facts in order to bring this case within the bounds of an extradition crime, both by misrepresenting that Julian Assange materially assisted Chelsea Manning in accessing national security information, and by misrepresenting that there was reckless disclosure of the names of particular individuals as alleged in counts 15, 16, and 17. That point engages that jurisdictional recognized in the successive cases of Costello, Morano, and Zakarovsky. We will deal with it more fully in due course. Third, because the request seeks extradition for what is classically political offense. Extradition for political offenses is expressly prohibited by Article 4.1 of the Anglo-U.S. Extradition Treaty. Therefore, it constitutes an abuse of this court's process to require this court to extradite on the basis of the U.S. Anglo Treaty in breach of the treaty's expressed provisions. That concludes my summary of the abuse case. I will turn to specific protections set out in the Extradition Act itself and the successive bars to extradition which we rely on. We say extradition should be refused for the following additional grounds. Firstly, extradition is barred under S81A by reason of political motivation of the request. It is directed at him because the political opinions he holds that have guided his actions. Moreover, extradition is barred under S81B because it exposes him to the real risk of discrimination on the grounds of his foreign nationality and political opinions at every stage of the criminal justice process in the United States. Secondly, extradition is barred under S87 because it would involve a flagrant denial of his right to a fair trial under Article 6 and is a clear violation of his right to freedom of expression under Article 10. Thirdly, extradition is barred because it would impose him to inhumane and degrading treatment contrary to Article 3. That is because of the risk of a wholly disproportionate sentence among in effect to a life sentence, and because of a virtual certainty of inhumane and degrading treatment in prisons in the United States, if not even worse fate. Fourth, extradition should be refused under Section 91 because it would be unjust and oppressive to extradite him by reasons of his mental condition and high risk of suicide if extradited. Fifthly, we say it would be unjust and oppressive to extradite him by reason of the lapse of time since the alleged offense. We rely also on Section 82. I will take these points in turn, but first, can I say something about the witness? I have before you a core bundle of witness statements. A tab references will be to that bundle. The key witnesses, whose evidence we propose adduce in relation to the history and political motivations of the prosecution and the free speech issues raised by it, are as follows. Professor Mark Feldstein, a distinguished academic specializing in broadcast journalism. Kari Schenkman, an academic who has made a special study of history of the Espionage Act and Computer Fraud and Abuse Act. Jamel Jeffer, executive director of the Knight First Amendment Institute at Columbia University. Professor Michael Tigger, a former journalist and academic specializing in constitutional and criminal law. Professor Noam Chomsky, professor of politics and a world-renowned author. Professor Paul Rogers, Emeritus Professor of Peace Studies at Bradford University. I want to summarize the history of these proceedings. History of the proceedings. The background facts are more fully set out in the chronological and in the particulars of abuse served on 20th February. Original conduct. Extradition is being sought for the receipt and publication of materials provided to WikiLeaks by Chelsea Manning. All the relevant conduct occurred between 2010 and 2011 and was known at the time. Yet Mr. Assange's prosecution and this request were not even begun until December 2017. And the superseding indictment on which the prosecution now rely did not come until 23rd May 2019. Moreover, during the intervening period, there was a well-published Department of Justice decision under the Obama administration that he should not be prosecuted. Chelsea Manning's court-martial. Chelsea Manning was arrested in 2010. She was convicted in 2013. At her trial, she explained her motivations for downloading documents and videos which exposed war crimes in Afghanistan and Iraq and the torture of detainees in Guantanamo Bay. In her plea statement to the court-martial on 30th July 2013, she stated, "The decision I made to send these documents and information to the WikiLeaks organization website were my own decisions, and I take full responsibility for my actions." At the time, no attempt was made to indict Julian Assange. The prosecution say that Julian Assange caused Chelsea Manning to obtain the material referred to in counts 2 through 4, 9 through 11, and 12 through 14. But her own account gives the lie to that false claim. Decision not to prosecute Julian Assange in 2013. A decision was made under the Obama administration not to prosecute Julian Assange. That was because of what has been described as the New York Times problem, which referred to the Washington Post article dated 26 November 2013. The U.S. prosecutors concluded that charging Assange would have been tantamount to prosecuting any journalist who published leaked national security information and would thus violate the First Amendment. Former DOJ spokesman Matthew Miller set out the main reason for the decision in 2013. If you're going to prosecute journalists for publishing classified information, which the department is not, then there is no way to prosecute Assange. This point was analyzed by Professor Feldstein at paragraph 9 of his report. He also referred to the long-standing precedent that publishing secret records is not a crime. As for all First Amendment experts make clear, it is for that reason that no journalist had ever been prosecuted for like conduct in the United States, despite thousands upon thousands of national security leaks to the press. Political war on journalists under Trump. But the principled and consistent stance taken under the Obama administration was reversed under President Trump's administration from early 2017 and onward. The prosecution, initiated later in December 2017, was the result of President Trump's effective declaration of war on leakers and journalists. You will see the expert reports that President Trump had repeatedly referred to the press as the opposition party and the enemy of the people. He also denounced the news media as a whole as sick, dishonest, crazed, unpatriotic, unhinged, and totally corrupt, and attacked them as purveyors of fake news. So it is no surprise that February 2017, President Trump met with FBI Director James Comey and agreed that they should be putting a head on a pike as a message to journalists over leaks and putting journalists in jail. As Professor Goldstein showed, President Trump then instructed his Attorney General to investigate criminal leaks of fake news reports that had embarrassed the White House. The Trump administration thus set about systematically punishing whistleblowers in general, and dramatically escalated the number of criminal investigations into journalistic leaks. As Feldstein further states, President Trump's use of government power to punish his media critics is a deliberate attempt to stifle the exercise of constitutional protections of free speech and the free press, such that journalists work under the threat of government retaliation. Julian Assange is a target. It was against the background that President Trump and his administration had decided to make an example of Julian Assange. He was an obvious symbol of all that Trump condemned. He had brought American war crimes to the attention of the world. Again, Professor Feldstein put it in this way. On a world scale, he disclosed significant government duplicity, corruption, and abuse of power that had previously been hidden from the public. He exposed outrageous and even murderous wrongdoings, including war crimes, torture, and atrocities on civilians. You will see set out in paragraph 4 of his report, page 6, the sheer scale and significance of retaliation brought about by Julian Assange and WikiLeaks, revelations brought about by Julian Assange and WikiLeaks. They range from a video of American soldiers shooting unarmed civilians from helicopters to the brutal torture of detainees in Iraq and the exposure of the true figures of civilian deaths resulting from the invasion of Iraq. Such revelations obviously put him in the sights of the aggressive America First ideologies of the Trump administration. The denunciation of Julian Assange, April 2017. That is why the prosecution of Mr. Assange, based on no evidence, was now pursued and advocated by the Trump administration, led by spokespersons such as Mike Pompeo of the CIA and Attorney General Sessions. They began denouncing him in April 2017. I refer you to the following. Firstly, a statement of Pompeo, as director of the CIA, on 13 April 2017, announced that Julian Assange and WikiLeaks is a non-state hostile intelligence agency. On the same occasion, Pompeo also stated that Julian Assange, as a foreigner, had no First Amendment rights. Then there was the political statement of Attorney General Sessions on 20 April 2017, that the arrest of Julian Assange was now a priority, and that if the case should be made, we will seek to put some people in jail. The full-scale denunciation is set out in a report by Professor Feldstein at page 19. We say these We say that these public denunciations indicate the political motivation that fueled the later persecution. They violate the presumption of innocence and the prejudice of prospects of a fair trial. And they form the context in which Attorney General Jeff Sessions, the political appointee with a political agenda, was directly responsible for the first indictment in December 2017. Thus, as Professor Feldstein showed, pressure was then put on prosecutors by the Attorney General and the new leaders of the Justice Department to bring an indictment, even in the face of vigorous debate from career professionals who were skeptical of its legality. And despite open objections from prosecutors directly involved in the case, that was the position in April 2017, as confirmed by reports in the Washington Post and New York Times on April 20th, 2017. The criminal complaint in December 2017. That is why, on 21st December 2017, a criminal complaint was made of computer misuse against Julian Assange, and his extradition on provisional warrant was sought. The timing is also significant because it coincides with the grant of diplomatic status by the Ecuadorian government. The US were, of course, well informed of all developments in the Ecuadorian embassy because US intelligence agencies had access to recordings of all conversations between Julian Assange and his lawyers in the embassy. I will develop that point further later, but by then, prosecution had become a political imperative. I will pass over the intervening period during which Julian Assange continued to have his conversations with his lawyers and family constantly monitored and recorded by a private agency acting on the instruction of US intelligence and for their benefit. Superseding indictment. Then in May 2019, a superseding indictment was proffered. That indictment charged Julian Assange under the Espionage Act. It charged him with the publication of state secrets in a multi-count indictment that dramatically ratcheted up the scale of the charges to pressure him and the potential penalties. As Eric Lewis shows, Mr. Assange faces 175 years in prison if he is convicted of all offenses charged in the superseding indictment. Unprecedented. This decision to prosecute for publication of state secrets was unprecedented. The unprecedented nature of this decision is stressed by witness after witness whose reports I have before you. The court referred to Professor Feldstein, Corey Shankman, Jamel Jeffer, Professor Michael Tigger. As Professor Feldstein says, the indictment breaks all legal precedents. No publisher has ever been prosecuted for disclosing national secrets since the founding of the nation more than 2 centuries ago. The only previous attempt to do so were highly politicized efforts by presidents seeking to punish their enemies. The belated decision to disregard this 230-year-old precedent and charge Assange criminally for espionage was not an evidentiary decision, but a political one. Jamel Jeffer, in his report at tab 22, characterizes the novel nature of the superseding indictment in equally troubling terms. I quote, "The government's indictment of a publisher under the Act crosses a new legal frontier. Swedish investigation and the timing of the superseding indictment. The timing of the superseding indictment, the March 23rd, May 2019, is also highly significant. At the time, the Swedish prosecution had just made 2 significant statements. On March 13th, 13th May 2019, they had announced that it was their intention to reopen the investigation of Julian Assange's sexual offenses. And on May 14th, 2019, they specifically announced that they intend to issue an EAW. The full facts are set out in the Defense reply of abuse of process paragraphs 53 to 54. As made clear there, the coincidence is too great. It leads to the inescapable interference that the U.S. ratcheted up the charges as to ensure that the extradition request would take precedence over any Swedish request. Again, this is not criminal justice. This is about the manipulation of the system to ensure the U.S. was able to make an example of Julian Assange. Accompanying abuses of power of the rule of law. The means employed in targeting Julian Assange further show that he had been made the object of exceptional extra-legal measures, and that this is no ordinary case. Invasion of legal professional privilege. First, his conversations with his lawyers were monitored and recorded by private security agents acting on behalf of the United States whilst he was sheltered in the Ecuadorian embassy. Then he was evicted from the Ecuadorian embassy after the intervention of the US. Finally, his confidential papers were illegally taken from him at the request of the US. That is confirmed by the second statement of Garth Pierce, tab 21, paragraph 12V, NBI. To pause for a moment, the evidence of illegal monitoring and the intrusion is set out in detail in the particulars of the abuse at tab 5 of the submission bundle at paragraph 36 through 39, and in the statement of witness 2 at tab 12. Can I turn to those briefly just to spell out the details? At this point, all this points to an agenda that has not confined a bona fide persecution. It also points to disregard of the rule of law. It violated the sanctity of diplomatic premise, and it took place in this country, which is relevant to the question of abuse. Pursuing Ecuador to expel Julian Assange. Then, too, steps were taken to ensure that he was expelled from the Ecuadorian embassy by the process of bullying and bribing Ecuador to expel him, so to make him available for extradition. This is set out in paragraph 43 to 45 of the particulars of abuse. Further breach of legal privilege. After the removal and arrest of Julian Assange, his legally privileged papers were seized. They have not been returned. See Garth Pierce's second statement on tab 21. It is respectfully submitted that the U.S. ought to clarify whether they now have access to those materials, why they were requested, and why they have not been returned to Julian Assange's lawyers. The pardon offer. Further evidence of bad faith and abuse of power at the heart of this prosecution is evidenced by the approach to Mr. Assange by Republican Congressman Dana Rohrabacher in August 2017. Mr. Rohrabacher visited Julian Assange to discuss a preemptive pardon in exchange for personal assistance to President Donald Trump in the inquiry then ongoing concerning Russian involvement in the hacking and leaking of the Democratic National Committee emails. You have now admitted the statements to Jennifer Robinson at tab 42. This statement sets out clearly that 15 August 2017, the visit took place to Mr. Assange in the embassy by Mr. Rohrabacher and a man called Charles Johnson, who we know to closely associate with President Trump. That they told Julian Assange and Jennifer Robinson that President Trump was aware of and approved of them coming to meet with Mr. Assange to discuss a proposal. And as the nature of the proposal itself, Jennifer Robinson explains in it in this way, paragraph 10 of her statement. The proposal put forward by Congressman Rohrabacher was that Mr. Assange identified the source of the 2016 election publications in return for some kind of pardon, assurance, or agreement, which would both benefit President Trump politically and prevent the U.S. indictment and extradition. Rohrabacher had publicly stated in the last few days that he and Charles Johnson did meet Julian Assange, that he did make the proposal about a pardon, but he denies that it was at the direction or the approval of President Trump. President Trump himself denies everything. But in the immoral words of Mandy Rice Davis, well, he would, wouldn't he? And there may yet be further developments in relation to this particular aspect of the case, prompted by the public reporting of this allegation last week. We say that this whole pardon indictment shows that just as the prosecution was initiated in December 2017 for political purposes, so too the Trump administration had been prepared to use the threat of prosecution as a means of extortion to obtain personal political advantage from Mr. Assange. So I'm going to end it there. I really thank everybody for hanging out and listening to me stumble through words for however long that lasted. I'll pop back up on here again and I will give it another try to go through the rest of the article. Thanks. You can follow us on Twitter at action_4 Assange. You can follow me personally at Andrew Sigmund. You can follow my co-host, Steve Poikinen, at Slow News Day, and you can follow Taylor at _Taylor Hudak. Thanks, everybody.